Hello friends, welcome to ABHI Law, where law is simplified. This is Professor Dr.Ambarish.R.Patnigere, and today we are going to start the lecture series on the Code of Criminal Procedure 1973. My lectures are basically designed for the BLS students and students who are doing LLB and those who are appearing for the competitive judiciary exam. I am going to explain the legal concepts as well as going to focus on important questions of the universities. Wherever necessary, I am going to quote important case laws to explain the section. So let's start the Code of Criminal Procedure 1973. The Code of Criminal Procedure 1973 basically originates from Article 21 of the Constitution of India, which guarantees that the person shall not be deprived of his life and liberty except through the procedure established by the law. That is why in the Indian court it is read as follow due process of law. Now let's remember, before this code of 1973 came into existence, there was already a code which was existing before. It was called the Code of Criminal Procedure 1898. This code was amended in 1973 and came in force on 1st April 1974. I hope so. This is sufficient for the background. But let me go a little further. When this amendment was being done, this amendment was done by the legislature keeping in mind three important basic considerations. The first one was that there should be fair trial. What do you mean by fair trial? Fair trial means principle of natural justice should be followed thoroughly. The second basic consideration which was in the mind of the legislature was every effort was being taken to avoid the delay in trial and investigation such that there shall be no harm to an individual or society at large. The third basic consideration which legislature had in mind was the procedure should not be complicated, it should be simple, it should ensure fair deal to the poor section of the community. With this, I hope so, I have made you to understand the background of the Criminal Procedure Code 1973. Now, let's look to the nature of the code. The nature of the code is like this. Basically, the law is divided into two categories. One is substantive law, second is procedural law. Substantive law means the law which talks about the right and duties of an individual. Example is Indian Penal Code. Another example is Prevention of Corruption Act. Now, let's look to the procedural law. Procedural laws basically determines the remedies. And the best example, what we are studying today, is the Code of Criminal Procedure 1973 as well as Civil Procedure Code. These are basically procedural law. But I want to mention you certain things which are very important at this particular time. Remember, Code of Criminal Procedure 1973 is not only procedural law, but certain sections in this code deals with substantive matters or substantive law. So they are substantive in nature. This is basically the nature of this code. Now let's come to the introduction part. Before we start the introduction, I want to tell you that when we are studying the Code of Criminal Procedure 1973, you require with you the bare act of Indian Penal Code, Constitution of India, Indian Evidence Act, as well as the bare act of Code of Criminal Procedure 1973, because this is going to be an exhaustive study. Let's start with the introduction of Code of Criminal Procedure 1973. Basically, this code has 13 chapters, 484 sections in it with two schedules, first schedule and second schedule. Both these schedules are part of this act. Now let us understand very important thing is that these schedules are very important. We cannot afford to neglect these two schedules. So I want to tell you something about the first schedule. First schedule is basically the classification of offences. It has two tables. Table 1, classification offences under Indian Penal Code, and table 2, classification of offence under any other act. Now let's come to the table number 1. It has total 6 columns in it. The first column talks about the section. The second column talks about the definition of the offense or description. The third column talks about the punishment. The fourth mentions that whether this offense is cognizable or non-cognizable. The fifth column talks about whether this offense is bailable or non-bailable. The sixth column talks about that this offense is triable by which court. So the first schedule is very important. The second schedule basically is been derived from section 476 of the CrPC 1973. What it has nearly 56 forms. These 56 forms are the forms which are required to be followed by the authority which is implementing this code. These forms are required to day-to-day procedure. Hence, I request you to go through these 56 forms. How we will go through these 56 forms? When we are studying the sections, we will see which forms is attached with that section. I hope so. This introduction is sufficient. Now let's come to chapter 1 of the Code of Criminal Procedure 1973. Students, I hope so you have the bare act with you and ready. Let's begin with chapter 1. As usual, in every act, chapter 1 is a preliminary chapter. In this preliminary chapter, there are 5 sections. Section 1 talks about short title, extent and commencement. Section 2 talks about definition. Section 3 talks about construction of references. Section 4 talks about trial of offences under the Indian Penal Code and other laws. Section 5 talks about savings. Now, we will see section 1 today in this video lecture only. Now, section 1 talks about short title, extent and commencement. It has basically 3 subclause. Clause A says that this act may be called the Code of Criminal Procedure 1973. Clause B says that it extends to the whole India. Now there is a proviso here. The proviso says that there are certain chapters, chapter 8, 10 and 11, which shall not apply to the state of Nagaland or to the tribal areas, but there is an explanation given. The explanation states that the state government may by notification apply such provision. The entire provision can be applied or modification can be done in these chapters 8, 10 and 11, and this can be applied. Either it can be applied to the entire state of Nagaland or any part of particular part of the state. The last clause is clause number C. It talks about that this law was came into force on 1st April 1974. With this, I have basically answered 2 objective questions which comes in the university. The first question which comes in the university is the chapters 8, 10 and 11 shall not apply to which state? The answer is very clear, state of Nagaland and to the tribal areas. Another objective question which comes is that when the Code of Criminal Procedure 1973 was commenced, and the answer is 1st April 1974. Students, don't forget these 2 questions which I have discussed. I hope so. I have explained you chapter 1 in a proper way. If you like my video, please give me a like, share it, subscribe it. If you have any special comment, my email ID is shown on the screen. Please put your comments on the email ID. Thank you.